All right, I'm here today with a friend of mine, Mr. Pete Wright. Pete Wright and I don't know if you know this, but we met in, would have been, I believe, August of 2013, we officially met. I had been to one of your Wright's Law programs here in Oklahoma.
Right.
I think I've been to 5 now. I'm not sure, or 6, something like that. But what's good about that is every
You need to
time.
get a life. Get a life.
Well, every time I learn something, though, I mean, seriously, I learn something new. What I really want to, I don't know if you remember this, but I came in with the Oklahoma Disability Law Center group.
Right.
Kayla Bauer.
Right. Kayla,
Yeah.
love Kayla, love her to death. So sorry she's not with us anymore.
Yeah.
I'm gonna start crying now.
Yeah, yeah. Well, and Kayla took me under her wing, and she basically,
Yeah.
she really, really did work with me a lot on different things. I think what you may or may not know is we went, a group of us, which I know you guys do every year, but we went to dinner that night, and I had the privilege of sitting right next to you and your awesome wife, Pam.
Mm-hmm.
And you guys just you took me in, and for a guy, I hadn't been to very many IEP meetings as an advocate at that point. For you guys to just kind of take me in, and it was overwhelming for me at the time. But I remember the conversation because I remember you saying something along the lines of, you were asking me questions about 504s. And I had not dealt with 504s, and you were asking me, a couple of questions, and I could tell by the look on your face that you knew I had no idea what I was doing. But you were gracious enough to sit and talk to me and help me out, and for that I appreciate that so much. What I want to kind of get into here is I want to start with, tell me your story. Here's what people may or may not know about you, because I don't know who's going to watch this. You quite literally wrote the book on special education law in as it pertains especially to schools, IDEA. Tell me how you got started. And I know that's a long story, but tell me what you want to tell me on this.
Well, you've been to a bunch of my programs, so you remember that I will typically open a program with my report card from DC Public Schools. The DC Public Schools told my parents I was mentally retarded, emotionally disturbed, and that I was uneducable. And in those years, back in the 50s, uneducable was a legal term. And if a youngster was deemed to be uneducable, school system had no responsibility to educate a child. There was a case in Pennsylvania called the Park case, which is what caused Congress to pass the law. So they were setting the stage for that with my parents. But then they got a comprehensive psychoeducational evaluation of me and found that I had streptosymbolia and an acute hyperkinetic disorder. Now, in those years, streptosymbolia was the word that described word blindness created by Dr. Samuel C. Orton. And they told my parents, because of the streptosymbolia, they had to find someone who was trained in this approach by Dr. Orton and Anna Gillingham to teach me how to read, write, spell, and do arithmetic, because I was basically illiterate. I had a bright mind, but illiterate. And that's what they had to do. And they found Diana Hanbury King. And this was around near the end of the first grade or so. And she worked with me for 2 years after school, almost every day, it felt like it every day, to teach me how to read, write, spell, and do arithmetic. And also I went to a residential Orton Gillingham camp up in Vermont, Mount Mansfield. It was operated by Helene Durbrow, and at the camp, Roger Saunders was my tutor, my camp counselor, my therapist, and everything. Roger Saunders later went on and became the president of the Orton Dyslexia Society, now known as the International Dyslexia Association, Diana Henbury King, became one of the greatest educators in the history of special ed, and very definitely in the field of dyslexia, dysgraphia, dyscalculia. She later created the Kildonan School, Camp Dunnebeck, and the Orton Gillingham Academy, and the National Teachers Hall of Fame several years ago gave her a Lifetime Achievement Award and called her the Einstein of education. And so she worked with me. Her goal was to get me not to age and grade level, but to 2 years above age and grade. I was given a comprehensive reevaluation in the 6th grade, and I scored in all domains, reading, writing, arithmetic, and spelling, at the 8th grade level. That was her focus, to teach me how to read, write, spell, and do arithmetic. And so that's kind of what got things started. The acute hyperkinetic disorder, they later changed the label to minimal brain damage. And then that label was changed by the American Psychiatric Association to minimal brain dysfunction. And now, of course, ADD, ADHD. And I was on meds in those earlier years to help me focus, because that part of the brain that helps you stay focused and pay attention, there was a deficit with those neurotransmitters, and that was what the meds did and how they helped. So basically, after around the 4th grade, I didn't do well academically, but I didn't have any problems with reading, writing, arithmetic, and spelling. I just had problems with the ADD stuff, and I still do. I mean, you'll notice I had trouble sitting still here today. It's a part of who I am. But so then after that, I attended DC public schools through the 11th grade and had a D+ average. By the end of the 11th grade, I could never have gone to a community college if they had one. And my parents had gone to college, and to them, education was everything. They sent me off to a Peter Prep school in New England. And it was not a typical Peter Prep boarding school. It was a Quaker school. And that's quite different from everything else. That's like a military academy, except you don't march with guns, but you had to wear coat and ties, and life was very regimented. And everyone had to play sports, and I excelled. I used to box. I played football in DC boys club all the way through, going up to Moses Brown in Providence, Rhode Island. And then I went up to the football team and played football there. Ended up in my 2nd year, became co-captain of the team, and got all New England. And also I boxed when I was in DC at the boys club. And so those 2 skills of boxing and football helped me persevere some of the earlier issues when I was younger with the bullying, because the bullying certainly happened. And Diana King told my parents, don't protect Peter from himself. And so when the bullying happened and I ran home one time, my mother asked me, what's wrong? And I said, they're bullies are outside. They're going to get me. They're going to beat me up. And she said, oh, well, let me see. And she opened the door, pushed me out, and closed the door and locked it. The bullies started laughing and they walked away, but it taught me a lesson that she was not going to step in and protect. And so the next time the same thing happened, when I realized, I couldn't run home, I hauled up and hit the person right smack dab in the eye and knocked him on the ground. Caught everybody by surprise. And then I walked away calmly, and I realized, act a little touched, act like you're not hitting on all cylinders, and people go, oh, watch out for Peter. He just might hit you if you look at him the wrong way. And so that was how I dealt with the bullying, by being unpredictable, and had to do that a few times. So then I took up boxing after that. So then there were no issues, boxing and football. And then I went to that school for 2 years. And after that, went to Randolph-Macon School in Ashland, Virginia. Focus was on psych and learning theory. And also sociology to an extent. And I also got all of the credentials needed to be a teacher. and I got my collegiate professional, whatever it was, certification as a teacher also, but I didn't really want to teach. I worked in juvenile training schools as a house parent, then as a counselor, caseworker, and then later juvenile courts, juvenile probation officer, and ended up at one point getting Virginia Juvenile Probation Officer of the Year, related in part to some work that I did with regard to reading problems and juvenile delinquency. Up on our website is a presentation that I made to the Association for Children and Adults with Learning Disabilities and also the International Dyslexia Association, then it was the Orton Dyslexia Society, about reading problems and juvenile delinquency. Um, and at that time, there was a youngster that I was working with that had dyslexia, and his tutor, his teacher, who was Orton Gillingham trained, came to see me at the juvenile court to tell me about dyslexia and about this kid and what was going on. And at the end of the conversation, I said, well, you know, I have dyslexia. And she said, well, yes, you know, lots of people have problems with reading or with spelling, but that doesn't necessarily mean dyslexia. And I could tell she was kind of blowing me off. You know, she said, oh yeah, that's okay. And I said, no, I really do. I had a lot of problems when I was younger with reading, writing, arithmetic, and spelling. And she said, well, you know, that's not unusual. And then I said, well, my tutor was Diana Henbury King, and my counselor at camp was Roger Saunders, and her mouth dropped. Oh my God, oh my God, you really do. You're one of the first. When did she work with you? And then and so that lady knew and evidently had worked with Diana Henbury King, and so she pulled me into the whole field. I was a juvenile probation officer, but had me join the Association for Children and Adults with Learning Disabilities, now known as LDA, and had me join the Orton Dyslexia Society, again, now known as International Dyslexia Association. And I started going to all the meetings and ended up doing a program at the national conferences. And so then I had a lot of people tell me I should go to law school. I heard that from judges and lawyers and others. And I had been in the juvenile justice system for about 10 years. And I decided, well, you know, and I'd gone up the ladder, the corporate ladder. So I was no longer working with kids in the street in the projects. I ended up I was training staff and supervising staff and things of that sort. And it wasn't as much fun as working in the streets with kids. And so I decided, well, let me look into this. And I applied to law school. And I had a mentor, Robert Shepard, Assistant Attorney General, who was very active in the LD circuit also, because he had a trial with LD issues. And I went to University of Richmond and stayed abreast of what was happening. That was before the special ed law was passed. It was going through Congress at that time, and I followed it all. And then the law was passed in '75. I got out half a year early. I overloaded courses and did summer stuff. And December, so I was able to take the February bar, began practicing law April '78, and immediately began, of course, doing juvenile court work because that was my experience. I knew all the judges in the greater Richmond area, not just in Richmond City, where I was a probation officer, but the surrounding jurisdictions, and doing special ed, of course, and ended up doing some training programs in special ed elsewhere in the country, and some of the national conferences. Did a program in South Carolina, and it was about 2 weeks before a case came out down there called Shannon Carter versus Florence County School District 4, and people came up to me. I did a keynote and several workshops about special ed law, and people came up to me and said, "Did you hear about this Carter case?" And I hadn't heard about it, but the Carters were there, and they had attended one of the training program I had done a year or two before, and they had a copy of the decision. They gave it to me. I went down to Kinko's, got their permission, went down to Kinko's, had a bunch of copies made of it. So I did one of my workshop sessions was about all the legal procedures, and I had them participate with me and use their case. And then I got a call 2 weeks later from their lawyer. The lawyer did a great job. David Burlington just did a wonderful job. And he called me, he said, "Pete, I heard all the nice things you said about me at the Orton conference, and you've been to the Fourth Circuit before in special ed cases. I haven't been, and I won this report, and the school system has appealed the case to the Fourth Circuit. Would you become co-counsel with me?" I said, "On one condition, that it's your case and I don't take it over, I'll just work with you." And he said, that's all I want. I don't want you to take it over. I said, fine, then I'm on. And so I was co-counsel with him, and we worked on a bunch of different things. And then I got a call from him. Pete, I got good news and bad news. The good news is, for me, I have been hired by the feds to become a Social Security administrative law judge. So the bad news for you, Pete, is your lead counsel. You're first chair, but our agency, the South Carolina Protection Advocacy Office, has another lawyer that's already up and running on the case, Nancy McCormick. She'll work with you, and um, uh, good luck. So I was the one that argued the case at the Fourth Circuit, and that morning, you don't know who your three-judge panel is at the Fourth Circuit until you sign in at the clerk's office. And that morning, when I signed in, I said, oh no, I saw who the three judges were. We have now lost this case. David Burlington won it in the district court, and I'm now arguing it before the Fourth Circuit, and we have now lost it before argument even starts. And why did I have that reaction? I didn't share that reaction with the Carters, but that was my reaction, because normally the three judges on a Court of Appeals panel are three judges from that court. But in this case, there were two judges from that court, and one was a retired Supreme Court justice. And they occasionally like to sit in on cases. Retired Supreme Court Justice Lewis Powell, who was a lawyer in Richmond, Virginia, before he went on the Supreme Court, and then later retired. But when he was in Richmond as a lawyer, he was also chair of the Richmond City School Board at a time when I had nailed Richmond City on several cases where they had to pay full tuition reimbursement, residential placements, and attorney's fees. And so I said, oh no. But the argument went very well. And the opposing counsel said to me, even, he thought we won it big, and he was concerned about how big we would have won it. Well, it was pretty big, because if you read the Fourth Circuit ruling, you'll see where the judge, one of the authors of the opinion, talks about how there's a split between circuits, and takes the Second Circuit to task, because there was another case very similar to the Carter case, but ruled the opposite direction. And so in that decision, it said there was a split between circuits. And there's only really two ways to get a case up to the US Supreme Court. And that's one, if there's a significant issue of policy, public policy issue, or there's a split between circuits. One circuit is going this way, and another circuit's going that way on the same legal issue. And so we had a split. And I knew it was going up. I mean, I knew if I was school board attorney, given that split, that's my green light, that's my ticket. And sure enough, they appealed it. And so a lot of other firms came out of the woodwork, wanted to take the case, and said, you can sit at counsel table, you'll be on the pleadings, but we'll do the brief, and we'll do the oral argument and all that. I said, my case, I'm taking it all the way. and I did. One of the fun things, nightmarish things, but fun things in preparing for it was, at that time, just shortly before, a book came out, oral arguments, cassette tape, a book of cassette tapes and transcripts of several dozen oral arguments before the US Supreme Court. And I spent whenever I was going anywhere, I was playing those oral arguments. They really kind of get you pumped up. And then I called all the lawyers who had Supreme Court cases related to kids, and talked with them, and got a lot of good help. So I argued the case, and when I went up there to argue the case, there was Justice Powell sitting off to the side in the BIP section at the court, and he looked at me and he went just like this. I learned that he wrote the whole paragraph about split between circuits. He's the one that forced it to go up, and we won unanimous in that case. And that case was about Shannon Carter, who had dyslexia, and the legal issue was getting reimbursement for it, even though Trident Academy in Norton Gillingham School down in South Carolina was not on the state's approved list of private schools, and the teachers were not special ed certified. And the New York case, Second Circuit case, held the school had to be certified and all this other kind of stuff. So that's why there was a split. And when we prevailed, that case changed the landscape, not just for kids with dyslexia or kids in private programs where the programs were not state certified, but changed the landscape for kids with autism. And we had didn't see this coming, caught us by surprise. And at that point, I'd already represented a number of kids with autism who were getting what was then known as ABA Lovas therapy, intense one-on-one, 40 hours a week, using this, this Lovas technique. And the therapists typically were not special ed certified. They might be graduate students in psych or whatever else. The lead trainer might be special ed certified, but so the parents could not get reimbursed for this very expensive 40 hours a week one-on-one ABA. And Carter changed that. Because of Carter, then, because not having to be certified, then the issue is it working? Is the kid benefiting from this private program? And yes, then the landscape changed, and that's when the flood of autism, litigation for kids with autism, getting reimbursement for therapy, took over, and then the floodgates opened in both directions. So now, up in New England, people talk about, I've got a Carter case. What's that? Up in New England area, a Carter case means a tuition reimbursement case. So you'll hear that language all the time. So that's kind of fun. So that's how it all went. And I was requested, many people contacted me with cases around the country, and I got involved in a number of cases in other circuits in other parts of the country, but I got spread thin. I was really getting spread very thin. And then had a mentor that said, Pete, you got all these techniques that you use, little tricks that you use when you litigate. And I do have a whole series of them that are pretty neat, pretty effective, and not well known. And things that I do, like I think you may remember the belief is that Pete Wright has a photographic memory. And I have no memory, but the belief among attorneys in Virginia or elsewhere was that I have a photographic memory, and it's all perception and a lot of things of that nature. And so a friend of mine, who is a author and a publisher, said, you got to put it all in writing, and you got to write some books about this, because when you die, it's going to die with you, unless it's in print, unless it's in writing. So we created the law book and our From Emotions to Advocacy. We had a tactics and strategy manual initially, and now and then shipped it over. And so then I started. I couldn't do all the cases everywhere and do all the training. And opposing counsel would set a hearing date on a case when they saw that I had a training somewhere. And so I had to kind of select. And so what I shifted over eventually was just only consulting in cases from time to time and doing a lot of training. And at one point I was on the road for 25 weeks of the year. I would leave home on Tuesday, visit the conference facility on Wednesday, do the training on Thursday, and fly home on Friday. And that became, and then work on our next book. That became kind of how my life changed. And now with COVID, it's shifting over to doing things like this with you, doing Zoom things. And I've done, I think, 2 live Zoom things, and also a podcast, audio podcast, and I'm having to ramp up in that direction. So that kind of tells you the story. And we have just now, my beautiful bride just walked in. Pamela just came in here. You're going to join us for a minute here.
What now?
You're going to join us. Go over here. Let me make some room for you.
Pam, how are you?
Hey, how you doing?
Good. I don't know if you remember me or not. We met. Yeah.
Yeah.
It's been a while though. So I was just talking. Yeah, some of the things you talked about there, Pete. That your little I don't know, your little tricks. A couple of things that I really that stand out to me. One thing that you always tell in meetings, and I tell parents, this is probably the best piece of advice I give to any parent that I work with, is if it's not in writing, it didn't happen. And I say that constantly. But for the record, I quote you constantly because, again, I've seen you 5-6 times. I've been through the trainings, plus the William and Mary thing, and I picked up so much from you, and I appreciate that. But yeah, if it's not in writing, it didn't happen. And you know, when
Yes.
you that's one of those things that people don't think about, but once it's said out loud, you think, well, why didn't I think of that? You know?
Yeah.
Yeah, you can't imagine the number of times when a parent would talk with me about an issue that's going on, and let's make it a speech therapy issue, and the school said, "We're really sorry the speech therapist is out on maternity leave, and your child's not going to be able to get any more speech therapy for the rest of the year. But we've only got, we're halfway through the year. We've only got the rest, half a year. So we'll pick back up with it next year, and we can't afford to hire anyone to replace her. But that's just the way it is. We're really sorry." And the parent says, "Can they do that?" And I said, "They just gave you a green light to be able to go out and get someone in the private sector to provide the therapy. How can that be?" "Well, because they can't use that as a defense. And do you have it in writing?" "Oh, no, no, no. This was, I talked with them on the phone, we had a meeting we talked about, but they told me there wasn't any more money in the budget. And so I had no ability to get any services for my child." And I said, "Is it in writing anywhere?" "No." "Then at this point, you have no case." No case, because I also tell parents, you have to assume you cannot testify.
Right.
You have to prepare your case as if you cannot testify. And if you just testify that this is what they told you, they're going to testify in many instances, "That's not what we said. I believe maybe that's what she heard. She misunderstood, misinterpreted." "No, what we got from her was an agreement to kind of just postpone services until next year, and we ramped them up. But no, I mean, if it was really critical, we could have made the funds available." In other words, if it's not in writing, it wasn't said. So the way it gets in writing is, I tell the parent, you have to write what we call the letter to the stranger. You've got to write a thank you letter for clarifying that because Mrs. So-and-so is out on maternity leave for the rest of the year, that there are no further funds and you can't do this and you can't do that. And I want to share with you that I contacted the chair of the Education Funding Subcommittee in the General Assembly, explaining to them that they had to make some emergency funds available for school districts like ours for when people go out on maternity leave, because this is what's happening. And I'm scheduled to have lunch with the person next week to see about a bill. Is there anything further that you would like me to bring up when I have lunch with this person? You put it in writing what they told you, and they can't get angry with you because you're trying to help solve the problem. So you didn't create an enemy. And if a stranger was to read the letter, assume the stranger is the judge's law clerk several levels later as the case goes up the ladder, who knows nothing about disability or special ed law or autism or dyslexia, but the stranger reads letters, "Oh my gosh, I mean, what a wonderful parent to try to do this." And the school can't deny they ever said that to the parent. You put it in writing in a way that opens doors for your services. You take a negative, take lemon, turn it into lemonade.
Yeah.
Take a negative, turn it into a positive.
Well, and to work off of that, another thing that I learned, and I use this constantly, a parent will call me and say, well, we were just in a meeting or something, and that this was said, or I'll walk out of a meeting, an IEP meeting, and I'll say, okay, I'm going to go I need you to email whoever, the special ed director, the school, somebody with the school, CC the superintendent, whoever you need to, and say, okay, according to what our last meeting, here's what I believe, and write it out. I think that you said this, this, and this, and it does two things. It starts that paper trail, as you always say, and then the second part of that is it gives them an opportunity to rebut and say, well, that's not exactly how it works. And then we've started a conversation. We've started,
Right.
a back and forth. Okay, so what did you really mean then? And we
Yeah,
have it
yeah,
all in
yeah.
writing.
Well, it also gives them a chance to fix the problem. It gives them like a second chance, knowing
Absolutely.
that there is a problem and the parent perceives it as a problem enough. People are very resistant to writing letters, and they think they can send a text or an email, but you can always fudge text and emails. Judges don't give that kind of stuff much weight.
Yeah.
So, yeah,
Uh,
yeah.
and I tell parents, you want to send an email. Thank you for the meeting yesterday and the clarification. And I want to be sure I really understood what you were telling me. And this is my understanding. And if I'm mistaken, would you please correct me? And on critical issues like the one that I use, the speech language being terminated for the rest of the year, then remember that judges, administrative hearing officers, administrative law judges, hearing officers, federal court judges, they don't like to read an email string. They want real letters. So I tell parents, if it's really critical, you write a letter. We have what we call a letter to the stranger. That's discussed on our website and in our books, so that it's a true professional looking letter. And I tell parents that you can take your emails and you know, if you're going to read an email string, you got to start at the last one and work your way up in reverse order to understand the history. And so I tell parents to take that and copy and paste and put it in chronological order. And in saying, because there were so many emails on this issue, I took the liberty of putting them in chronological order. And on XYZ date, I emailed to you this and that, and on so-and-so date, you replied this and that, and kind of have it follow a sequence. And for letters, I tell parents, write the letter, convert it to PDF, attach it to an email, send it by email, and send it by snail mail, by US mail.
For those with Pam just starting, if you look at the bottom, see she is the co-write on this too. So anybody that's
Yeah.
which
Thank you for our books. I appreciate that.
Oh,
we can hire you as our marketing expert.
Hey, listen. I've got, this isn't my my typical one. The one that I use when I go into IEPs has all the I've got tabs everywhere. I've got highlights everywhere. I use that constantly. So
but that in itself is a little intimidating for people at the meeting.
Sure.
They know you're prepared. Yeah.
Yeah, it is funny because I've actually pulled that out at a meeting, and things, you can just tell the whole atmosphere in that meeting changes, and I'm just looking for something, which kind of comes back to what you were just talking about, the second part of this, Pete. I love the Columbo effect, and I use that constantly, which is, I'll tell you about an IEP meeting I had where and I'll give you just a little bit of this, but the school, the student had transferred in from a different school. The school didn't want to use the IEP, but they also didn't want to change and meet to change the IEP. So we called a meeting anyways and said, okay, what had happened was the school that they were in previously had said that they needed a para in the classroom. Well, this school didn't want to give a para, obviously, but they also didn't want to reassess and change, do whatever they needed to do. And so I pulled out the book to explain to them that they either have to go off of the previous IEP or they need to do all the assessments to change. And I mean, as soon as I pulled that book out, I mean, the whole look on their face, and all I was looking for, but I slid it across and I said, well, maybe I don't understand this part. Can you explain this part? And yeah, you'd have been proud. But I love that. I love the Columbo that maybe I don't understand this. Can you explain this to me?
Yeah, absolutely. Yeah. Most of the parents that came in to see me were angry. They were out for blood. They had put some gasoline on the fire, thinking that they were enhancing their case, when in fact they were really hurting it, and it was getting very polarized because of the positions the parent was taking and the way they were working with the school district. And I tell parents that, it's not about the law, it's not about the facts, it's all about marketing and selling. You want to market to them and sell to them so that they, once they really understand and see it through your eyes, they want to go ahead and right the wrong and provide the services. And that is not easy. That is much, much harder than raising your voice, banging your fist on the table and telling them they're violating the law and you're going to sue them. Because when you do that, then after you've left the meeting, they go call the school board attorney and say, we got a live one, we got a hot one here, we got to get our, our ducks in a row and our wagons in a circle, and all of a sudden, you're behind the 8 ball. And I tell my parents, so that's the way they are many times when they came in to see me, and justifiably so, because of the things that did or did not happen. I don't blame the parents for that, but if they're going to get services for the kid, they're going to have to come in from a different perspective. And you want to present an image of being Mrs. Manners, who's merged personalities with Mother Teresa, Peter Falk, Columbo. You're always nice, you're always gracious, and when someone is throwing a zinger at you in an IEP meeting and trying to make you feel bad about your position and attacking you in front of everyone else, you kind of smile and you make like you don't quite get it, you're not quite there, that you just missed that part of it. And one of the other tricks and techniques I share with people is when you find this happening and you want to respond to the person and you want to flash back at them and in front of everybody, first realize if you do prevail and you do embarrass them in front of their own staff, you have now really ramped up having an enemy for life. Okay, so I tell people what you need to do to avoid that is, and I practice this in my office, I will get them going in a dialogue and then I'll turn up the heat and get them angry about something. And I'll tell them, find a spot on the wall just a few inches off from the person's ear and look at that spot. Don't look at the eyes or the lips or the face. Look at that spot. And that will help you kind of set up a wall and emotionally distance, and you'll be able then to calm down. And at the same time, I had all my parents write on a legal pad. I've got one here. I tell them on a legal pad, never write anything on the first page, because one time there'll be a break in the meeting, a bathroom break, and you might have all your notes, you might leave your pad there, and someone's going to be going over looking at it while you're out of the room. So never write on the first page, always start on the second page. And I would tell them in the upper left or right-hand corner, super small, so nobody can understand what it is, one corner or the other, microscopic print, write 5W plus H plus E. And it's microscopic, so if someone sees it, they don't understand what it means. But you know what it means. And it's a reminder to you that when you're put on the spot, you got to change the tone or the direction of the discussion. You ask a question. When you're told, well, don't you think this is the best IEP meeting? Best IEP that we have ever written for your child? And the parent thinks it's the worst. They can't say it's the worst. They have to say, well, and you think 5Ws plus H plus E. Who, why, what, where, when, how, and explain. And all they got to do when they're put on a spot is think, what do politicians do when they're put on a spot by a reporter? You say, well, the question I guess I have is, who's going to implement this IEP? When do you think it'll happen? You don't have to know where you're going. You start a sentence with one of those 7 words. Your brain will help you come up with other stuff, and you immediately follow it with another one. Boom, boom, like that. And then they'll start talking, and then you can formulate and think through the question you want to ask, so you can change the direction of the meeting. And we have a whole thing in our book about how to basically control meeting dynamics and then take charge by that technique, by the 5Ws plus H plus E. And so
let me just say,
yeah.
it's a very good technique for like somewhat timid people or people who are not very assertive, is if they can just, and they're anxious about going to the meeting, if they can just say, well, who is going to be providing that service, speech therapy? Well, and then it's like, well, we are hiring now, we have an ad out, and school starts next week, so obviously there's no one. Or what times, where will it be, how will it be done? When will it be done? So but generally, if you ask a question that starts with one of those letters, you're in a room of educators and you won't have to ask much else. If you can just get a couple of questions out and then shut up and then shut up, then they all, because they're teachers, if you say, I'm confused, who's going to do this? They will all rush in and you will get more information. Like they don't have anybody yet, that kind of thing. Just those questions. I don't understand. Who's going to do it? When is it going to be? How? And just shut up. And they will fill in 5 or 10 minutes.
Yeah, let them do the work. Yeah. Well, my philosophy as a lay advocate, I think, again, I borrow so much from you, Pete, but my first thing I say when I go into an IEP meeting, if I've not met with the family or with the school before together, is I'm not here for the parent and I'm not here for the school. I'm here for what's best for the child. That's my number one philosophy. That's always my goal, is what can I do to help this child? But my second part of that is, what can I do to keep the family calm? Make sure that because I know you catch more flies with honey. And what can I do to keep this from going beyond into due process? Those are my three main focuses when I go in as an advocate. And I think that's something that, again, I've learned from all of your teaching. And but I want to make sure that kid's getting the best thing. Oh, and of course my job, I mean, I don't know if you guys know much about, since 2013 when we met, in 2016, I got a grant from the U.S. Department of Ed, Office of Special Education Programs, to run a nonprofit organization here in Eastern Oklahoma. I'm in a rural area of Eastern Oklahoma.
I remember talking I think we had dinner or something of that.
Yeah,
Yeah.
we did.
Yeah,
Yeah.
he talked about having dinner together
Yeah.
with Kayla there.
Yeah. And so that's what I do. I'm a full-time advocate now. We run a resource center, but
Wow.
one of my main jobs is to do. I'm a lay advocate for IEPs and 504s and things like that. So that's always been my philosophy. Is how can I best help the child? And that should be everybody's focus when you walk into that room.
Yeah.
So, but I owe that, in large part to your teaching, and not just the ISEA, which was an amazing experience. I came out of that, by the way. I remember sitting there and thinking, I'm at William and Mary Law School. How is this? I'm not smart enough to be here, And
we kind of felt the same way.
it's amazing. It's an amazing feeling, but
Yeah.
and my second feeling after that week was overwhelmed. I mean, there's just so much. You can never take all of that in.
Mm-hmm.
Some of the people who watch this later may not be familiar with what we're talking about.
Sure.
ISEA, Institute for Special Education Advocacy, at William and Mary Law School, and it's a week-long program. And Kayla Bowers, Oklahoma Disability Law Center, and ourselves and William and Mary kind of all joined forces to create this. What, 10 years ago?
10 years.
10 years ago.
Yeah.
So it's been every year running, and you were in the 2013 class. Yeah. And it was supposed to be in coming up end of this month, but because of COVID, it's been pushed back now to I think January. Yeah. And then there'll be another one, but then the next one is still on board for end of July of 2021.
Yeah. I was cleaning out my closet the other day and found my Rights Law Army hat the other day.
Did you really?
Yeah.
Everybody got a hat that had William and Mary Law, Rights Law Army.
Yeah.
The scales of justice, I think, or something like that.
Yeah.
Yes.
Of the cases you've worked, I don't know how many. You probably don't know how many. Probably would be my guess.
Yeah.
Are there any that stand out to you? I know you hit on Carter earlier, which was, pretty groundbreaking. Anything else that kind of
Yeah,
stands
yeah,
out?
yeah, yeah. There's one I'm very excited about in terms of what's happened so many years later. In my training, I talk a lot about the letter to the stranger and how important it is. And there is one letter that I reference, and when I when I give the quiz, on the back side of the quiz is a bunch of resources, and one of them was a link to the letter to the stranger in the Joseph James Cameron James Upper Arlington, Ohio case, and that was a letter that a parent wrote to the director of special ed for Upper Arlington, Ohio. Child had dyslexia, was being educated at Kildona School, Diana King School, and parent wanted the child to come back to public school, but the parent had pulled the kid from the public school because the public school was using reading recovery to teach a child with dyslexia. And the research has shown that there's a lot of research that says reading recovery damages a child with dyslexia and puts the kid further behind, makes it much harder to turn things around. And unknown to the parents at that time, that the Upper Arlington's use of reading recovery, that was the first time it was used in the country. And so that particular school was where it got its first foothold in the United States. So Upper Arlington, Reading Recovery, and Ohio State University all working together on it. And so the parent's letter to the stranger addresses that in part. And one of the themes of the case that I had was we were seeking tuition reimbursement for the Kildona placement, but also the parent did want the kid to return to public school, but said, I have got to see the IEP before I agree to enroll my child. And the school system said, we're not going to do an IEP until you enroll your child. And parents said, no, we don't dare do that. And so they were, just, it was kind of like this. And it was my position that the law did not require that the child be enrolled. There was a case out of the Sixth Circuit where Upper Arlington and Columbus, Ohio is located, that referenced in passing, unrelated to this, about the necessity to enroll a child before preparation of an IEP, but that was not the issue of the case. It was just mentioned in passing and not a litigated issue at all. And I said that case doesn't really apply here. And the school system said, yes, it did. And they dug their heels in. So parents asked for a special ed due process hearing. And that letter to the stranger was the theme of our case and reading recovery. And we stipulated before the hearing officer in Ohio that the parents would not enroll the child until they saw the IEP. And the hearing officer said, well, based upon that stipulation, then I find as a matter of law that you have to enroll the child because of the so-and-so case. Therefore, your case is dismissed. The school had filed a motion for summary judgment. We appealed it to a review officer. Columbus, Ohio is a two-tier system. In most states, losing party can appeal straight to federal court or state court. Some states, losing party appeals from hearing officer or ALJ, administrative law judge, to a review officer or review panel, and then to federal or state court. But there are a two-tier system there in Ohio. And so the review officer said, based upon the stipulation and the Sixth Circuit's decision in Wise, case dismissed. We appealed the case to the U.S. District Court. And as a part of the complaint that I filed on the appeal was I attached the parent's letter to the stranger, and I had it actually notarized. So it became kind of like a verified exhibit, like a verified pleading. Not really evidence, not live testimony, but as close as you can get, like an affidavit being filed with a motion or something of that sort. So I attached it, and the judge said, well, I want to confirm that parents will not enroll the child until they see the IEP. And he said, yes, sir, that's correct. Then there's really no need to hear any further evidence on it. This case is dismissed. So we never had a full hearing at any level so far. But that was in part because we stipulated. I didn't want to have all kinds of long drawn out testimony and then have it dismissed on that. And so then we appealed to the U.S. Court of Appeals for the Sixth Circuit. And when I did oral argument before the Sixth Circuit, two of the judges asked me detailed questions about the parents' letter. They obviously had read the letter, were impacted and moved by it. And they reversed and ruled in our favor and sent it back down to the district court for a full hearing on the merits. And I had already made it very clear that I was going to really open up the can of worms about the financial relationship between Upper Arlington School District, Reading Recovery, and Ohio State University. And I filed a bunch of requests to admit and motions to produce documents, financial records, blah, blah, blah. Boom, settlement offer came in. That was one that couldn't be refused. Case settled, never happened. But, and the school was going to be making, as a part of the settlement, they're going to be making all kinds of changes about bringing Orton Gillingham into the school district, training teachers in Orton Gillingham and everything else. And so parents were happy. It looked like things had turned around. And then a few years later, it all backslid again. And the school district went back downhill. A parent in Upper Arlington who was having similar issues 10 years later was searching the internet and found Cameron James's letter to a stranger on our website. It's on our website, found that letter, read it, and then digested everything about the case, found the Sixth Circuit ruling in our favor, and said, oh my gosh. And
almost identical facts in her case.
Yeah.
I mean, it was like,
yeah.
like 20 years, 15, 20 years later. Yeah.
And a reporter had gotten involved and had filed Freedom of Information Act requests and got it was a confidential settlement agreement. And if parents violated the confidence, they had to pay money back and do this and do that or else. But the reporter got it through a FOI. And so that was made public, not by the parents, but by a reporter. And this parent said, they backslid again. So they found the parents' letter and they set up a whole organization of parents and ended up a bunch of complaints were filed with the Department of Ed in Ohio.
At the same time.
Yeah. Against the Upper Arlington School District. And they prevailed in the complaints filed with the State Department of Education. And the the Upper Arlington School District had to make a bunch of changes. There were some major staff changes made, new director of special ed, and the new director of special ed has turned around and taken that school district into becoming what I think is one of the best special ed departments in the country. Upper Arlington School District, all of the special ed teachers, not just the ones with kids with LD, are getting training in Orton Gillingham. They use Orton Gillingham extensively now in that school district. And what happened is these parents got together and created a professional video. It was about $20,000 to $30,000 spent. A lot of funding came in. We put some money in, and they created a video all about what's happened, what's going on, all about kids with dyslexia and how things can turn around and what's going on now in Upper Arlington, and it is moving. It brings tears to your eyes. Yeah. And it's
our dyslexic children.
And the website where it is our dyslexic children.org.com. We have a link to it on our rightslaw.com website.
Somewhere.
And yeah, it's there, and it is just awesome. I mean, with Sally Shaywitz is in. I mean, they've got professional cast of characters, professionally done, and my understanding is it's on the docket for going on PBS or some other a bunch of different things beyond just YouTube. It's on YouTube, and they wanted to make sure that all parents could get it without having to pay lots of money, without having to pay a fee at all. So that's why it's out there and available. But that's one that I just feel so good about because it has had the Joseph James case and the parents' letter has had such a ripple effect Now, didn't at that time we thought it would and thought it did, and it started to make some changes, and then it didn't. But then these parents came back and really picked up the ball, and it's an awesome one. So,
Yeah, no, I think that's great. You know what I've always loved, Pete, is your passion for these cases. These I don't know anybody that works harder at reviewing cases, other cases, and I remember sitting in one of your trainings, and you were just spitting out cases left and right. You need to go read this. You need to go read that. And of course, I'm writing down. I need to read this. I need to read that. You know, but there's such a passion in it, and it comes out. And for that,
Loves it. He absolutely loves it.
yeah.
Yeah.
And
well,
oh,
I'll share with you. You know, I'm telling you, I'm saying you got to go read this, you got to read that. Well, what we've done now is so you won't have to go out digging and trying to find what I'm talking about. In 2015, we came out with a book. I call it our year in review book. It's what's the actual title? It's
Special education legal developments and cases
in cases,
for that
and then
year.
2015. So we came out with a book, and that book has all of the cases issued by U.S. courts of appeal around the country related to special ed. And
With idea in 504.
in 504, and what always troubled me as a lawyer is I would read an article about a so-and-so case, and it is the person that wrote the article, it's their perception of the case or their spin about the case. And so many times I would find that I didn't quite agree. And I read so many articles about my Carter case written by law professors and other people, and they were wrong. They obviously missed it. They didn't get it. They didn't understand exactly what the outcome was, or this or that. Or they turned some of the facts around and got the facts confused as they were writing the article, and it really irritated me. And it happened many times, especially but my case. And I knew it was happening with other cases. And so this book is different. We didn't try to give you our summary and review an opinion about the case. Instead, and as a lawyer, when I wrote my briefs, this is how I tried to do it, and so how we did it in this book. We took the actual words of the court and copied and pasted them. Many times in reading a federal court decision, it's confusing, it's convoluted, it's hard to follow because of the way they'll tell you what the legal history was, the factual procedural history, this and that, and the issue is impacted by the so-and-so decision, and it gets so convoluted sometimes that you can get easily lost. So I took the words, rearranged the order of the cases, synthesized it down to 1/10 of it, but it was all direct quotes. So we have all the cases from the courts of appeal and using the court's own words. We just finished up on our 2019 book. So we did it for 5, this is our 5th year, I guess. Yeah. And that's going to be hitting the store on our website in the next couple of days. And there's some exciting cases in there. I mean, so yeah, I do really get excited about so some of them are bizarre. One about a medical student with dyslexia, had all kinds of modifications, accommodations, the usual standard ones, all the way through, I believe it was undergraduate and through medical school. And then it got to be the final testing that's done, the medical boards before they go out and do residency. And they decide none of the accommodations modification will be permitted. And yet been having them for years. And it's a big lawsuit. It's kind of fascinating to read how the court analyzed it. And then another case in there, child with Down syndrome who had significant toilet training issues and had been in this private daycare facility for about 1.5 years or so. And they said the child's going to have to become toilet trained by XYZ date. And they set a deadline, and kid had not, but this was the nature of part of it, having Down syndrome. And they kicked the kid out of daycare, violation of ADA. And Department of Justice got involved and filed a big lawsuit. And so we had that in there, and some other really neat cases. And so uh, I tell lawyers who are getting into this field, I recommend you get those books and skim through them. You don't have to study them with a highlighter and take notes, because what you read in 2015, that those set of facts by the same court in 2020 may be a different outcome. But by reading from the beginning to the most recent, you see the shifts as the law changes. And you'll be better able to predict the outcome of that same case in 2021 because you've seen it evolve and grow and take a left turn and a right turn and striking course again. And that's happening all the time with law.
I've edited the book and did some work on it. And I was struck by something Pete wrote in the introduction because he was explaining what he just told you about how things evolve. And he's talking about, and he said at one point, you may feel a sense of wonder as case law evolves and changes. A sense of wonder. And I thought, I don't know how many people read the law actually feel a sense of wonder, but he does. I mean, he gets so excited about some of these cases and how they're inching things, or maybe not, maybe taking bigger steps toward making things better. And or going in different directions.
We have one bad development. And sometimes when I finish up these cases, many times you don't know who the attorneys are. But I use PACER, provided it's available from federal courts, and I go in and read the pleadings and find out the lawyers and get the phone numbers, and I'll give them a call, talk with them about their case. And we have two cases out of Colorado in the 10th Circuit where the parents, one of them, the parents won tuition reimbursement, and school appealed, and got up to the Court of Appeals. And in the prior district court order, the court not only upheld the win, but also ordered that the school pay the parents' attorney's fees, as is in the statute. I mean, they have to if they prevail. And it went up to the Court of Appeals because the school appealed it. And the Court of Appeals said, well, the public school has been paying the child's private tuition since the hearing officer's decision under a stay put. Therefore, the parents are really not out money because they've been paying it all along. Thus, the case is now moot. There's no issue because the kid's been out of that private school, a couple of years because the case has taken so long, dragged out so long, so it's moot. Therefore, we're vacating the district court decision and the case is dismissed. The parents lost all entitlement to attorney's fees, even though they won at each level. Bizarre. So we have a new thing starting to, so then another decision later on referenced that and said, we're going to make this decision vacant. We vacate it. Moot. Vacated as if the other decision hadn't happened, and parents lost entitlement to attorney's fees. And so we have a new trend. But now if the lawyer alleges, and I don't think they could have in this case, but if the facts were such they could allege the child, because of the school's failure to provide FAPE initially, and the parents had to put the kid into a private program, and there was that time gap when they deprived the kid of free appropriate public education, and a gap of time, the kid lost educational services. And so we also want, for that 6-month period, we want compensatory education in addition to tuition reimbursement for this other placement. Then that would have kept the case alive when it went up to the Court of Appeals, and they wouldn't have been able to vacate. Just a simple little thing. When the parents say, I don't want compensatory ed, they just pay my tuition, that'll be fine. But you better put it in there, otherwise you may get nothing at all.
Right.
And this is a new spin. It's going to have to take place.
Yeah. That book may be the only book that I don't own that you guys have written. So but I'm going online today, and I will buy the latest copy.
You can't get it from our web. You can't get it from us yet.
Not the new one.
No, it's not in the store yet. It is ready, but I don't want you to go online and buy it. It's an Adobe PDF. It's a PDF file.
Okay.
The print version, you got to go to Amazon. Amazon does our books. Our year in review books on print on demand.
Okay.
Type. Yeah.
Okay. Well, and so your website, rightslaw.com, for any parent that is working on IEP, for any advocate, for anybody that is interested. It's amazing. I think it's well laid out in that it's easy to find. What I go on there quite a bit, and I
Would
find,
you repeat that for Pam?
I think it's pretty easy to find. I really do. I mean, I think it's pretty easy to navigate. I can find the things that I need. Of course, I've been on there enough that I kind of know where everything's at. So, but
Yeah,
uh,
it's so big, and
I
we've
think
added so much stuff over the years that
that's
the only way I find stuff is to Google it
yeah,
myself.
yeah. It is true. There's so much information on there. It's a little overwhelming.
Yeah,
And that
yeah,
but
and,
when I need something, I know it's going to be on there. So.
yeah. I need to
I
find a way to do it so that when people go to a page, say the IEP main page, that the most important articles are here. And then if you're looking for IEP meetings, here's a page. Or if you're looking for particular conditions, a child with hearing problems, a child with ADD, whatever, you can go here. And so that they can start with the most important stuff and then go down to the things that they feel are urgent, or most interesting or whatever. But
Well,
to do that, it's like 40,000 pages. I'll be dead before I get started.
She wants us to redo the website. And when I'm doing my training, I've had so many people say the same thing you're telling me now. And I know myself, when I'm researching a legal issue and I want to see what else is out there, and I put in something, so many times it takes me back to our own website. And I go, oh, I didn't know that we had that in there. That was 10 years ago, but it's still relevant today. Yeah. And so Pam wants to redo the whole thing. And we're at odds on that. That's why I had you repeat that.
okay. Well, I'm not picking sides. I'm just saying. Hey,
There's some fairly small changes we could make that would make
yeah,
it a
yeah.
little better.
I'm out of time. I could talk to you all day long, but because of time on this, I'm gonna have to cut it short. But here are a couple things I want to say before I get off here with you. Number one, you have changed the lives of many people through your work, through your advocacy, through your tutelage, through everything. And I want to say thank you for that. As a parent of a child with a disability, actually I have two, one with autism, both have severe ADHD. So for that, thank you so much. The other part is just, you've helped me over the years, not just with your training, but as I said before, just taking me in that, in 2013, and the dinner, as little as that may seem, that is it was enough to push me in the right direction and say, okay, I know what I'm supposed to do. And for that, I thank you. So
Thank
Well,
you.
we
Thank
thank you,
you.
Cody. We
Yeah.
thank you.
you both were great. So thank you so much. And everybody go to rightslaw.com and pick up that stuff.
Thank you.